Hi and welcome back to the Black Belt Barrister channel. If you're new here, please do hit subscribe and the bell icon to receive notifications of new videos. Today I'm talking about the topic of trespassing, whether it is civil or criminal, and the laws revolving foraging and the right to roam. Broadly speaking, trespass is a civil matter and not a criminal one, but there are some exceptions. Firstly, and most commonly understood, it is a criminal offence to trespass on the railway, that is to go somewhere that you are not ordinarily supposed to be, which for most people should be quite obvious. Similarly, under section 128 of the Serious Organised Crime and Police Act of 2005, it is a criminal offence to enter or to be on any protected site in England, Wales or Northern Ireland as a trespasser. And whilst being on private land as a trespasser is usually a civil trespass matter, hopefully it goes without saying that causing damage whilst on the land or being abusive or threatening to the occupier might well amount to a separate criminal offence. Equally, the owner of the land who forcibly removes a trespasser with excessive force might well be committing an offence of their own. Now, whilst this is rarely a problem when someone comes onto your land without permission, such as a child retrieving a ball or someone cutting their hedges and standing on your land to do it, these sorts of things are not usually the cases that are going to be the source of serious concern. So most of the notices that you see that say trespassers will be prosecuted are usually meaningless, unless the land is a protected area or a railway or some other kind of restricted area, such as a restricted area of an airport or military training ground or something of that nature, then you might face more serious consequences. As to trespassing on your neighbour's property to carry out repairs to your property, you may first look to your title deeds, which may well set out the circumstances in which you can carry out those repairs and access your neighbour's land. Failing this, the Access to Neighbouring Land Act 1992 provides that you might apply for a court order to access your neighbour's land in order to carry out those repairs, although this particular law does not extend to Northern Ireland. There are also some peculiarities, like abandoning a vehicle on some private land also amounts to trespass. So for the most part, trespass can amount to nuisance rather than a criminal offence. However, there are some instances that it would amount to a criminal offence outside of the protected and restricted areas that I've mentioned. For example, in England and Wales, squatters, raves and hunt saboteurs are covered indeed in criminal law. For example, if you enter a residential building as a trespasser and remain there, and you knew you were a trespasser when you entered, and you have the intention or you are living in that building, then you are committing a criminal offence. This offence can attract a prison sentence of up to 51 weeks and a £5,000 fine. So obviously, thinking about the requirements, this does not apply to tenants because they were not there originally as a trespasser. A similar difficulty has arisen over the years with unauthorised encampments or travellers on open land. And indeed, a government consultation on this area has just finished a few days ago from the date of recording, with the view to criminalising the act of unauthorised encampments throughout England and Wales. Next, I'm going to talk a little bit about the right to roam and the right to forage. The right to roam is often understood as the right to access land without the use of a footpath or designated walkway area. This is often referred to as open access land or simply access land. This area can include mountains, moors, heaths and downs that are privately owned. But it also includes common land registered with local councils, which can include things such as the land around the England Coastal Path and national trails around all of England's coasts. It's worth bearing in mind that there are certain things that you can and cannot do whilst exercising your right or freedom to roam. Broadly speaking, you can utilise open access land for walking, running, exercising, climbing, or indeed watching wildlife. Although some things that you cannot usually do on open access land, believe it or not, include horse riding, cycling, camping, taking animals onto the land, and more understandably driving vehicles, except of course mobility scooters and powered wheelchairs. Where open access land also includes a body of water, you cannot ordinarily carry out water sports on there either. There are also restrictions about taking dogs onto such land between the months of March and July and at any other place or time that there are livestock. This is to protect nesting birds and other animals. But you may also bear in mind that this doesn't apply to public rights of way or assistance dogs. It's also worth to note at this point that there are some areas that appear on maps of open access land which you cannot access. These are known as accepted pieces of land. These sorts of areas include housing, land that is used to grow crops, building sites or development land, certain parks or gardens, golf courses, railways and other working quarries and things of this nature, although many areas of accepted land will have a public right of way. As for the law on foraging, that is, taking something from land for your own consumption, can be a little bit more difficult, but there are some broad guidelines which should steer you okay. Broadly speaking, under the Theft Act, any person who picks mushrooms growing wild on a land, flowers, fruit or foliage from a plant growing wild on any land, does not steal or commit theft when he picks what he picks, unless he's doing so for the sale or other commercial purpose. So broadly speaking, if you are legally on some open access land and you take something for your own consumption and you're within these restrictions, then you're generally going to be okay, as long as you're not taking it for commercial purposes. There are some exceptions, of course, because in certain areas the bylaws are going to prevent you from foraging, but there will usually be signs up to let you know that that is not okay on this particular area. You also cannot start cutting at branches and certainly not uprooting plants, because this is prevented by the Wildlife and Country Act 1981, and it would be an offence to do so. And it is also worth noting at this point that your entitlement to roam on that land will cease if you are found to be damaging any such plant, and to return after you've been asked to leave would then amount to trespass. Finally, there are always some other specific issues that you should be aware of. For example, there are some sites of specific scientific interest that have special rules attaching to them, and certain plants that would amount to an offence if you are taking them or distributing them, such as Japanese knotweed. It's worth bearing in mind that these sorts of things will carry different laws and penalties. Overall, many of these things can employ a degree of common sense. If there's a sign saying you shouldn't be doing something, then you shouldn't be doing it. If it looks like it is a commercial area and you are mistaken, then I would exercise caution. If it's obvious that it's private land or there's a house on it or some other kind of building or construction on that land, I would steer clear. On the other hand, if it is quite obviously countryside or you've checked and it is registered open access land, then you would be free to roam and to forage on that land, providing that you stay within these safe parameters. Now, I dare say that if you are cycling on such areas whilst you're not strictly permitted to do so, you're probably not going to be challenged. But if you are challenged, I would suggest that you comply with the restrictions and stay off the land, because otherwise you'll be returning as a trespasser. But again, the application of these laws in most cases will employ a degree of common sense. So whilst this seemingly straightforward topic has probably opened up just as many questions as those that I've answered, I'm happy to research some general points and answer your queries in the comments as to my objective view as to whether what you're doing is permitted. But of course, and as always, you must seek formal legal advice if you are in any way unsure about what you are about to do or about something that you have already done and you're being questioned on. But in the meantime, thank you for watching, and please make sure you subscribe and hit the bell icon to receive notifications of new videos. And I'll see you next time.